for having me today. My name is Fatma Salah. I'm in the private practice for 17 years, and I'm also teaching civil procedure law and arbitration in Cairo University for 10 years. I would speak to you today about the dispute resolution and alternative dispute resolution landscape in Egypt after the uprising that took place in 2011, or what is said to be the Arab Spring, and how it affects the dispute climate in Egypt. Looking back at 2011 and the subsequent 3 years, maybe until 2014, one can notice how devastating was the effect of the what is said to be the Arab Spring on the Egyptian economy as well as the Egyptian society, which in return affected the volume of disputes and the alternative dispute resolution mechanism in Egypt. During this period, business in Egypt has experienced severe interruptions due to demonstrations, riots, frequent changes of law, rapid changes in politics and reshuffle of governments. All these circumstances caused serious interruptions of the local as well as the international investment in Egypt, which resulted in a flood of litigation and arbitration against the Egyptian government to recover their losses. I will be focusing today on the investor-state disputes, whether the local or the international, or the disputes with the Egyptian government or the Egyptian affiliated entities and companies, and the role of the out-of-court forum in settling many of these disputes. Let me first give you a quick introduction to the Egyptian legal system for you who are not familiar with Egyptian legal system. The Egyptian legal system is based on the French system and to a lesser extent on other European system, as well as the Sharia law, specifically in relation to family law matters. For the judiciary system, it is mainly divided into two systems: the general courts, which has general jurisdiction over all civil, commercial, and criminal disputes, and it is composed of 3 layers, or if we can be more specific, 2 layers, and the Court of Cassation on the top. The Court of Cassation is not an appeal stage, it's a court of law, reviewing the judgments from review the law points. It's not a trial court, so we have 2 trial stages and the Court of Cassation. This is for the general court system. We have also a separate court system, which is called the administrative courts, or what is called in French the Conseil d'État, or the State Council, which have exclusive jurisdiction over disputes with the governments or any dispute with official, with governmental officers. We have also the specialized courts. In 2008, in the context of judiciary reform, an economic court system was established to be exclusively, to have exclusive jurisdiction over economic and commercial law matters, either in the civil or the criminal aspects. So economic courts now have exclusive jurisdiction over capital market issues, over companies law, over competition, over intellectual property matters, and we have also the specified or specialized circuits, internal circuits inside the courts. As my colleague said, we need judge experience. So now we are developing the specialized circuits inside the court. So we have judges who are only dealing with labor. We have labor and employment circuits. We have tax circuits. we have contract circuits, we have tort and tortious liability circuits. And we have on top of these courts the constitutional or the Supreme Constitutional Court, which review the constitutionality of the laws and regulation which are referred to the Constitutional Court by any of the courts. Also, my colleague mentioned and asked if it is a general problem for other jurisdictions, the delay and the complex system. Yes, it is definitely in all jurisdictions, I guess. In Egypt, a typical civil or commercial litigation would take from 4 to 6 years, excluding the enforcement stage. This duration is a little bit shorter for administrative court. Administrative court can take from 2 to 3 years, also excluding the enforcement stage. So the Egyptian legal system, as many other jurisdictions, suffer from the insufficient resources, inefficient administration, and the high caseload. A judge can decide or hear about 300 cases per day in Egypt. So it is in the civil and commercial cases, it is paper-based. It is rarely allowed to, the judge would allow you to give a hearing or to have a hearing. Hearing now is only confined to criminal litigation, but in civil and commercial, it is very rare. It is only paper-based. That's why arbitration used to be or early recognized in Egypt as an alternative and recommended alternative, a recommended alternative dispute resolution since 1960s. We have the arbitration regulated in the civil procedure law in 1968. And then we have a separate comprehensive arbitration law in 1994, which was considered a milestone in having a comprehensive, straightforward, and simple arbitration applicable on international and local arbitration, and following the unilateral arbitration model law. Egypt is also a signatory of the New York Convention, the Exceed Convention, the Arab Investment League Convention, and it is also signatory to more than 100 bilateral investment treaties, which are allowing dispute resolution through arbitration or, either under the UNICITRAL or other international arbitration center or the Exceed. The judiciary has played an important role in Egypt in enhancing and supporting arbitration and the execution of arbitration hours. So we can say that the Egyptian judiciary is friendly to arbitration, and it is always creative and supportive. Last month, we have what I think is a landmark arbitration decision in which the court in Egypt upheld an ICC interim decision to stop the liquidation of a letter of guarantee in a huge construction dispute, in what we can call a courageous step in supporting arbitration and supporting and respecting the arbitral awards. Also, although liquidation of stopping the liquidation of LCs is not allowed under or rarely allowed under Egyptian law, and it is a well-settled principle in the judiciary, the Egyptian court respected the ICC interim award and enforced it as it is without reviewing the merits or the reasons behind it. Going back to 2011 and what happened, I will give you examples of the cases I handled, and I was lucky actually to live in such rocky time and deal with such complex litigation. One of our clients is a Saudi real estate company who was assigned to build a hotel and a touristic resort over the Nile River, and was allocated a big plot of land over the Nile exactly before 2011. Due to the 2011 and the Arab Spring, all the projects stopped. Strikes all over Egypt, riots, the land was occupied by local, and the project is just stopped. The Egyptian government gave the investor 1 year extension, another 1 year extension, and 2013 it withdrew the land, although it was fully paid. The client sought our advice. What are the alternatives we have? We told the client, you have the court system, you can challenge the decision of the government to withdraw the land before the administrative courts, which will rely on the force majeure, and it will take from 2 to 3 years to have a decision, a final decision. And you have the arbitration under the Arab League Investment Treaty, and you have the negotiation and the mediation with the Egyptian government under what was established, or what was established at that time, is what is called the dispute resolution committees. The government of Egypt at that time, specifically the Ministry of Investment, established committees that were formed from a judge, from the investment minister, from experts, to solve or to try to amicably resolve disputes with the investors. The client chose to go for the course. The client didn't prefer to go to the dispute resolution committees for mediation, because at that time their decision was not enforceable. So the client thought that this would delay the process more than giving them a conclusive result. And they went to the court, and the litigation is still before the court until now, from 2013 until now. This is one example. Another example of the difficulty that we faced after the 2011 is what we can call the third-party public interest litigation. So we have political activists who file and initiate lawsuits against transactions that has been concluded by Mubarak or during Mubarak era, saying that these transactions were tainted by corruption, and therefore it should be nullified and the transaction should be reversed. This transaction related to big transaction, big and heavy sale transaction, like factories, selling factories, privatization of public estate factories and companies. I have been representing Lafarge cement production company, the French conglomerate, in this litigation, where the political activists, who are third party, who are not related at all to the transaction, filed the claim before the State Council or the administrative court, asking the judge to reverse the sale, the privatization transaction that took place in 2008, which means like 15 years, it took place in 2002, which like 10 years ago, and reverse the transaction. The factory should be returned back to the government, the employees should be returned back. And astonishingly, the courts accepted the claims, not only for Lafarge, but for other 20 multinationals. 20 Egyptian court judgments were issued reversing big transactions, asking the multinational to return back the factories and the investment and take their money back and return back the employees. It was a state of chaos. I was representing Lafarge. Lafarge was not the one who purchased the factory from the government. It was Titan. Titan then sold the planet to Orascom, and then from Orascom to Lafarge. And the claim was filed against Titan, the government, Titan, Orascom, and Lafarge. And now the Egyptian government is in a state of chaos, which resulted in a flood of arbitration against the government. Egypt was a defendant in about 18 exceed arbitration during the period from 2011 to 2014. 18 exceed cases was filed against Egypt during this period. Matters started to improve and be better after we have the presidential election. We have a settled government in 2014, and the government, the new government and the new president starts to think how we can fix what happened, how we can attract foreign investors, how we can restore the trust in our economy. And many actually many steps have been taken in this regard. Number one, a law was issued to ban any third-party litigation against the governmental transactions. If an activist think that there is a corruption in one of the transactions, this activist should go to the public prosecution and file a criminal claim, not to go to the court and ask for the reverse or the cancellation of the government. So this is number one. The government to stop such litigation. Number two, we have the new investment law, which was first introduced in 2015, and now we have a comprehensive new one in 2015. The new investment law was, is generally aiming at attracting new investment to Egypt, offering more incentives, offering more guarantees, and what is important to our session today is adding a new chapter for out-of-court forum dispute resolution. For the investment guarantee, as you can see, the law is providing for clear provision for the fair and equitable treatment of foreign and national investors. So foreign investors are now guaranteed a fair and equitable treatment as national investors. No expropriation, no nationalization, a clear undertaking from the Egyptian government to respect its contracts unless there is a final decision from the court of corruption or fraud. Also, the right to repatriate profits and repatriate capital. One of also the major and important guarantees is shielding the senior executives from prosecution. So if the company committed any violation, the CEO should not be charged. The one who should be charged is the responsible employee in the company, not the CEO itself. This is also another important guarantee in the new investment law. For the investment incentives, we have reduced value-added tax, reduced customs duty, reduced energy prices for specific sectors, and we have the new chapter offering alternative dispute resolution, out-of-court alternative dispute resolutions. The investment law, the new investment law, provided or created 3 different committees to resolve dispute resolution. The first committee is called the Complaint Committee, where an investor, either local or foreign investor, can challenge a decision that was issued by a governmental entity refusing to give it a license or approval, and this committee should issue its decision within 30 days. Its decision is mandatory, and this is the new thing. It is mandatory on the government. So if the committee issued a decision against the government itself, the government is mandated to, by the law, to enforce the decision. The committee, the first committee, is composed of a judge from the state council or from the administrative court, from the minister of investment, the minister himself or herself, and an outside independent expert according to the relevant with the topic of under dispute. We also have the investment contract committee, and this committee is a ministerial committee. It is headed by a judge from the administrative court and includes many ministers, the Minister of Finance, the Minister of Investment, the Minister of Civil Municipality, the Minister of Defense, and they review and hear cases from investors who signed contracts with the government. So if you have a contract with the government and you have a dispute with the government, you can think of going to this committee before going to arbitration or litigation. Its decisions are mandatory on the government, not on the investor. And this is an important thing. First of all, it is not a prerequisite to go to court. So you can, after going to this committee, you can still go to arbitration or litigation. You can skip it, and you can go directly to arbitration and litigation. Its decision is mandatory on the government, not the investor, upon signature of the Prime Minister. The last investment, the last committee, the investment committee, it is also competent to hear disputes in relation to the application. If any governmental authority violated your rights or your guarantees under the investment law, you can go to this committee, which also its decision is mandatory and immediately enforceable without going to the court. It's immediately by the law. It is immediately enforceable, even if it challenged after that in the court. I will skip this slide due to the time. I will just give you an overview of the numbers. During the last 2 years, these three committees have heard have held more than 660 disputes. The value of the disputes it has settled is about 120 billion Egyptian pound. Many of the litigation I told you about in the Exceed have been terminated and amicably settled by this committee. It is the contract committee is mainly handling complex litigation, and you can go to these committees during arbitration or before going to arbitration. I hope my presentation was useful. Thank you.
Thank you very much.